truly and faithfully and to the best of my ability, knowledge, and judgment,
perform the duties of my office without fear or favor, affection or ill will,
perform the duties of my office without fear or favor, affection, or ill will,
and that I will uphold the Constitution and the laws.
and that I will uphold the Constitution and the laws.
They are all connected to Guwahati.
Yes.
He is the Bangla brother-in-law, right?
Yes.
May I have your lordship's permission to conclude the proceedings?
The court will assemble for judicial work at 11:15 a.m.
मोटो रेजर 50 अल्ट्रा ने फ्लिप फोन्स की दुनिया को ही फ्लिप कर दिया है। इट इज द मोस्ट इंटेलिजेंट फ्लिप फोन। इसमें है गूगल जेमिनाई, गूगल फोटोज के एआई फीचर्स और बहुत सारी एप्स सपोर्टेड ऑन द मैसिव एक्सटर्नल डिस्प्ले। 4 इंच का कवर डिस्प्ले आता है जो सबसे बड़ा है।
कैमरा अमेजिंग क्वालिटी का है। ये स्मार्टफोन बहुत ही ड्यूरेबल है। IP-X8 अंडर वाटर प्रोटेक्शन गोरिल्ला ग्लास विक्टस लगा हुआ है।
प्लस इसमें है Qualcomm Snapdragon 8s Gen 3. Moto Razr 50 Ultra is truly a standout flip phone.
Motorola Razr 50 Ultra. Flip the script.
Hello, Moto.
इस साल 29 जुलाई से 3 अगस्त तक भारत के सर्वोच्च न्यायालय ने लोक अदालत का आयोजन किया है। इस साल सर्वोच्च न्यायालय अपने 75वें वर्ष की वर्षगांठ पर इस स्पेशल लोक अदालत का आयोजन करते हुए ये ध्यान में हमने रखा है कि सुप्रीम कोर्ट में काफ़ी मामले नागरिकों के लंबित हैं और मैं आप सब से गुजारिश करता हूँ, लिटिगेंट से गुजारिश करता हूँ, वकीलों से, एडवोकेट्स ऑन रिकॉर्ड से कि इस लोक अदालत में आप हिस्सा लें ताकि ये सारे जो मामले हैं इनमें जहाँ हम कर सकें इनका हम निवारण कर लें और शीघ्र लोगों को न्याय पहुँचाएं। we begin, I must share with all the members of the bar that we are very honored to have in our midst Justice Antonio Herman Benjamin, a very distinguished scholar and international judge from Brazil. He's due to be sworn in as the Chief Justice on the 22nd of August this year. We're very privileged to have Justice Antonio with us. He's a great friend of India, one of the foremost international experts on the law relating to the environment. So he's just come back from a trip to Srinagar, Sonmarg, Kargil, Leh, and back. So he drove all the way. He's very fond of India, and we're just sharing with the colleagues what his experiences about that trip. So we welcome you in our midst.
On behalf of the bar also, my lord, I welcome the honorable guest to this.
Thank you. So we'll start with our daily board.
Lord, may I just mention, my lord, I have circulated a mail. The reason is, my lord, my lord, I mentioned it before vacation. Lordship said it will be listed. It was not listed because it's an old matter. Regarding a PGI admission matter, my lord.
All right, I'll list it, yes.
My lord.
Lordship, may I mention?
Just circulate an email and I'll attend to it in the afternoon today.
Fine.
Just circulate an email and I'll get your matter listed as quickly as possible. All right, let's see the first case.
My lord, may I mention item 40? My lord, by the time the matter reaches on board, my lord, NTA can be directed to produce the original OMR of the...
Nothing of this sort, wait for the matter to reach. Yes, item 1.
May I please, my lord? In item 1, this is a bail plea, my lord. The petitioner is in custody since 10th of February 2022.
In possession, you were alleged to be in possession of 80 kilograms
I
of
was
coffee.
not found on the location, my
You
lord.
are not. They say that your identity cards were found in the vehicle.
No, it's
You're
not in the identity card, my
You're
lord.
not the registered owner of the
I'm not the registered. I have placed it on record, my lord. The registered owner says in his cross-examination, he has been cross-examined.
allegation is that the vehicle has been transferred in your favor.
He says, but in the cross-examination, he says he cannot confirm if the vehicle that has been alleged to be found by the police is the same vehicle which he sold to me, even otherwise, my lords.
All right, we'll issue notice here and keep it after 2 weeks. Serve the standing counsel for
I'll
the
serve.
state of Madhya Pradesh.
I'm most grateful, ma'am.
Issue notice, returnable on liberty to serve the standing counsel for the state of Madhya Pradesh. He has been denied. Antonio.
I'm most grateful, my lords.
Item 2.
Very short question is what is the
There's a
relevant?
delay of 235 days.
There is a delay, my lord, because
Why
of
should
the
we condone
evidence.
the delay?
My lord, there was.
And look at it this way. When they first filed their claim before the tribunal in Madhya Pradesh, you objected to the jurisdiction of the tribunals, relying upon the judgment in VA Tech. True,
Fine.
the judgment in VA Tech has been overruled subsequently.
now.
But at that stage, at your behest, you were sent to the arbitrator. You didn't object to his
By the
jurisdiction
High
before
Court,
the
my lord.
arbitrator.
By the Honorable High
Right.
Court.
But then you never objected before the arbitrator. Now there's an award.
It's a matter of record that we objected only at the stage of 37, my lord. I
37.
cannot
So-
quarrel with that.
And we'll dismiss it. What we'll do is we'll dismiss it on the ground of limitation so that it doesn't become a precedent in any other case. And we'll
Question
keep the
of
question
law.
of law open. There's a delay of 235 days in filing the special petition against the judgment of the Madhya Pradesh High Court dated 9 December 2022. Full stop. There is no satisfactory explanation for the delay. Full stop. Hence, the petition is dismissed on the ground of delay. However, we clarify that since the bar of limitation has intervened, it has not become necessary for this court to express any opinion on the question of law raised,
It will remain open, my lord.
which is kept open. We shouldn't say it's open because actually the question of law is decided in your favor
My
by
lord.
our judgment of
Lions.
2018.
Lions.
Because the judgment in VA Tech has been overruled by our court.
That is
So
there, my
if
lord,
we
but
keep
it
it,
says.
if we keep it open, we are tacitly then casting doubt on our judgment. The question of law is in your favor. Just that we are not interfering in this case only.
At this stage, my lord, if I may only
Then we'll
point
say it's
out-
kept, the question of law is kept open. Fair enough. You want it, we'll give it to you.
I'm very grateful, my lord.
Please, my lords. My lords, this petition has become infructuous because subsequent developments have taken.
Counsel appearing on behalf of the petitioner states that the petition has been rendered infructuous by subsequent
I'm
development.
sorry, I want the question of the law to remain open, my lords. Simply being, my lords, because this for the second petition, my lords, pursuant to a settlement agreement. And lordship's court has
always open queas. Nothing is concluded by us. We are just saying that it's infructuous. Item 4.
My lords, it will ultimately, the matter will ultimately reach the lordship's court only. So I'm just.
So it's always open queas. We are saying it's disposed of as infructuous. It can never bind a future bench.
I'm very grateful, my lords.
In this matter, admittedly, the NCLT finds that my claim and my allotment to the flat is reflected in the information memorandum, which is the basis of any resolution plan. And it is showing in the record.
What about delay?
Yes, my lords. On delay, my lords, admittedly, I am not present when this pronouncement is made. My lords, the matter is reserved 3 months back. It comes in a pronouncement, my lords. My appearance is not there. I have vehemently said that I was not present. It is uploaded, my lords, and
What is the date on which it is uploaded?
my lords, it is uploaded on 22nd of August 23, from which, my lords, I am within limitation, excluding the certified.
You were not present. Were you a party?
Yes, it was my application, my lords. On my application while reserving.
But then if it's your application.
Yes, my lords.
Then can you say that I was not present? I don't know because.
So, my lords, the arguments happened. The order stands reserved.
But it is.
Not,
when is the order pronounced? Actually, it's not pronounced at all.
Not on the dates argued, my lords. Not on the dates heard. It comes up in the list 3 months after for pronouncement.
22nd August.
No, my lords. 11th of August. 22nd August is when it is uploaded, and which is when I gain knowledge of the order. And I, my lords, file immediately. I filed the appeal immediately.
Learned counsel appearing on behalf of the appellant submits that that in the application which was filed by the appellant, though the order was passed by the National Company Law Tribunal on 11 August 2023.
Yes.
The order was uploaded only on 22 August 2023. Hence, it has been urged that the appeal which was filed on the appeal was October 2023.
Yes. 10th October 23.
10 October 2023 would be within the period of limitation of
61-2.
The limitation. We'll issue notice.
Great.
Returnable on.
Malaj, may I only make one request? The resolution plan basis which my application was dismissed even to date has not been approved by the NCLT. Now, Malaj, may I only request for an interim stay until.
We'll make it returnable in 2 weeks.
Grateful.
Stay everything. Serve Dusty and come.
So great.
Item 5.
Yeah.
Please.
See, in this case, the NABARD, though initially it said that, there may be certain irregularities in the functioning of the bank. Subsequently, it filed an affidavit before the High Court stating that the resolution of the board was proper and that there were no irregularities. Ultimately, this was a public interest litigation. You brought some grievance to the attention of the court. The court has felt that it is not necessary to interfere.
Case 368 may be seen, Lord, for a moment.
What is that?
Ordered by High Court, Lord, Honorable High Court.
The earlier High Court, the earlier order.
Yes, Lord. It says, Lord, pursuant to previous order, action taken, report on behalf of the NABARD has been placed on record. Prima facie, certain allegations were stated to be true.
But that is prima facie. Subsequently, NABARD files an affidavit and says that we have now looked at it and there's nothing.
Later, Lord.
Anyway, as a PIL petitioner, your duty was to point it out to the High Court. High Court went into it. NABARD is a national bank for rural development. They file an affidavit. Now, why should we?
But the error is page 389 may be seen, Lord. Uttar Bihar Gramin Bank, as well as not the sponsored bank, Central Bank of India was directed to take decision on this erroneous activity. That is my.
But look, ultimately, as a bank, it is regulated by the state authorities, since it's a state bank, as well as to a certain extent by the Reserve Bank of India. Why should we presume that they will not look into the any regulatory failures in the bank?
Not any fraud above 3 crores is directed to be investigated by CBI. But here the quantum is not above more than my lord, 500 crores. My lord, that is.
Sir Counsel, we are referring to the affidavit filed by NABARD dated 21st February 2024, where the averment is that it is humbly submitted that as per the specific directions dated 18 January 2024 of this court, the instances pointed out in the special audit report were scrutinized. On scrutiny, respondent number 4 is satisfied with the resolution of the board of UBGB that the guidelines of fraud are not applicable to the present matter, audit report, and therefore the matter is not required to be referred to local police/CBI as per clause 9.1 and 9.2 of respondent number 4.
My lord, initially, my lord, 13.
I think we made our point clear. I think we'll not entertain it further. It is a PIL after all. Yes, dismissed. Item 6.
Okay.
Item 6. Yes, Mr. Raghunath, you are on the screen.
Advocate Raghunath on the part of, on behalf of
Filed a writ petition before the High Court for early hearing of your appeal before the DRAT. And now you are in the Supreme Court under 136. We're not going to entertain these kind of...
Your Honor, my lord, these steps will be against the order of the Honorable High Court, and there is no supervisor. There is no, about 24 hearings have happened.
What do we do? The tribunals are, it's not that the tribunals don't have work. They have their own priority.
But my lord, it's a question of recovery of 208 crore rupees.
I know, but you're postulating that your case is the most important to be reaching the line or the queue. Other cases may be as important before the tribunal. Why should we expedite your case? We'll not do anything like that. Thank you. Dismissed.
This is a petition seeking appointment of an arbitrator. The clause of arbitration which finds place in the SPA was SHA, which was initially disputed by the other side, gradually accepted on an affidavit and recorded by the High Court in its order, saying that they were trying to mislead the court, but they've then accepted the existence of the SHA and the arbitration clause. We are only seeking appointment of an arbitrator because one of the respondents is a Sri Lankan citizen and the other is an Indian citizen, both of them being shareholders in the company, which was created pursuant to the SHA.
My lords, I'm appearing for the respondents herein. Let them supply me a copy. I'll come back in 2 weeks and give my no objection for the appointment.
For the appointment of the arbitrator?
Yes, my lords, after perusing the agreement, because there was a confusion about the agreement per se, the notice of invocation says the arbitrator.
Fair enough. You're appearing for both the respondents, right? You're appearing for both the respondents.
Yes.
Fair enough.
Well, they have admitted the existence of the...
He doesn't have a copy of the papers. He's on caveat. So
I'm not on caveat also. I'm just appearing.
Issue notice. Mr. Can I have your name?
Karthik Malhotra.
Mr. Karthik Malhotra, Senate counsel appearing on behalf of the, states that he has instructions to appear on behalf of the respondents and seeks a short adjournment to take instructions. A copy of the paper book be supplied in the electronic form to the Senate counsel for the respondents. List on, should we keep it on Monday and finish it on Monday?
Please, my lords.
My lords, Friday.
All right, next Friday.
Next Friday.
Very good. Next.
Yeah.
Man.
Item number 8.
My lords.
The candidate who was selected as the president of the Consumer Disputes Redressal Commission for Mallarkotla,
Sangrur.
For Sangrur. The candidate who was selected resigned.
Within 6 months.
Within 6 months, in which case you are the second candidate. You have no vested right for appointment.
No,
if the candidate does not accept the appointment, then the second candidate can say that, well, appoint me to the post. Once a candidate is appointed, then the select list comes to an end because the process is complete.
Our submission was only this, my lord, that the OM says that if a person joins and resigns or vacates within 1 year, then, my lord, the merit list has to follow. In this case, my lord, the OM is there and the judgment of my lordship, 3 judges of this court have said. And my lords, this is since no, that's right, my lord. But my contention is that since this is a judicial selection, instead of going through a fresh selection process, my lord, people can, and I'm there in the merit, my lord.
The government picked out all candidates who are lower in the list. That whole selection process in Punjab was replete with all kinds of
What they have
difficulties.
done is, in my district, Sangrur, after my lord,
Because the Punjab government thought that they can just pick up candidates who, are, suitable to them, overlooking the select list.
so that's my case. When one resigned, they appointed someone who was not even in the list, who didn't even apply. I was there at number 2. They
But
didn't call
see,
me.
his appointment may be invalid, but
So
he
our-
has no vested rights.
So
right?
here, he's R5, my lords, he's R5 here. I said so in my LPA. When the writ was pending before the honorable single judge,
Whom did they appoint?
they appointed one Jyot Karan, who was not even in the select list.
No,
Page
but look at
70 is the select list.
But look at it this way.
Yes, ma'am.
Your plea was appoint you. You're not really concerned about his appointment.
In the writ petition, it was appoint me. When the judgment is reserved in the writ petition, on that day, they appoint this person. I filed an LPA. I said, how can you appoint him? You have to appoint me. The OM is there in my favor. The 3 judges is in my favor.
Did you ever challenge his appointment?
In the LPA. Because in the writ petition, he was not appointed. He was appointed on the day when the judgment in the writ petition was reserved. So I could not have made him a party in the writ petition. I made him immediately in the LPA.
So you can.
I made him immediately in the LPA. I made an application, and he's R5 here before your lordships. A person who is not selected is working, my lord, as a presiding officer of the Consumer Forum, and I was there in the merit list. As in the wait panel. OM says, my lords, the panel.
Petitioner, the grievance of the petitioner is that the candidate who was first in the select list, right?
Very well.
The candidate who was first in the select list for appointment to the post of president of the Consumer Disputes Redressal Commission, Sangrur, resigned. Full stop. Thereafter, full stop. The petitioner was second in the select list. Full stop. According to the learned counsel, after the judgment was reserved by the single judge,
Yes.
and before it was delivered,
Yes.
the 5th respondent was appointed
Yes.
as the president
Yes.
of the District Consumer Disputes Redressal Forum, though he was lower.
He was not in
Though he was not in the merit list
Yes.
at all. Full stop. The petitioner has been non-suited on the ground that once the first candidate, was it a fresh appointment then? They just picked him up without
Picked him up without anything.
All right, we have recorded your submission. The grievance of the petitioner, therefore, is that even if he was not eligible to be appointed as the grievance of the petitioner is that the selection of the 5th respondent is completely contrary to law, since his name did not figure in the merit list at all. Full stop. Issue notice returnable on after 2 weeks. Dusty permitted in addition. Liberty to serve the standing counsel for the state of Punjab in addition. You have come here after 280 days delay.
Father passed away during this period. Father was very serious.
280 days is too bad. And on interest, claim is on interest in addition to the return of compensation.
I invite your lordship's kind attention, but page 19 only. Page 19, just, it has been recognized. It has
What's
been
the point?
approved. Yes.
What's the point that you want to make?
Well, it has been approved. It has been said that yes, this due is there.
You have to open the door. You have to first get the delay condoned.
My father passed away. I have said so. And he was bedridden, and
there's a delay of 280 days in filing the special petition, for which there's no satisfactory explanation. Full stop. The petition is dismissed on the ground of limitation.
I circulated a note yesterday evening.
Yes.
My point is that it's a statutory violation. I'll be under remedy.
Tell us one thing. After the conciliation proceedings failed before the Facilitation Council, you have said that they never called upon you to file a statement of claim.
No statement of, I was a defendant, so no statement of claim is filed, no evidence, nothing. Just that the initial claim form which is filed before the MSME, which is a unrecent, just one page of form. On that basis, only the ultimate order is passed.
You get to file your statement of defense.
We did get to file those. We got to file those. But the cancellation, how it failed was that the first day I show up without the Wakalatnama, that day itself, the other side prefers an application, already pre-drafted application. And on that basis of the application, same day, immediately the order is passed, there's no cancellation possible, let's move. But section 65 of the Arbitration Conciliation Act says, mandatorily, both sides have to be called upon to file the written responses, and that concession has to happen in good faith. Even UK law and all, they have gone on to that level where they say that good faith.
That conciliation failed. Thereafter, what happened before the?
No conciliation happened. Then I was called upon to file my defense. I filed. Then arguments reserved. Some fellow, Mr. RK, heard the arguments. The ultimate award is passed by some other 3 people who have not even heard the matter. So RK is the signatures on the
You have come here against which order?
Well, I've come again the order passed by the division bench of the High Court saying my 34 is not maintainable. I should have gone on 34. Writ petition is not maintainable.
But you have a remedy under 34, right?
Well, I won't have a remedy under 34 because section 65 violations of the Arbitration Conciliation Act are not palatable under 34 grounds.
No, but there's what you are aggrieved by finally is the award.
Well, I've tried to draw a distinction from that India Glycol judgment, which is falling for my lord. I'm conscious of that. There's a Jharkhand Urja judgment in my favor, which says if the mandatory statutory violations have taken place, then writ petition is maintainable vis-a-vis the MSME Act. Squarely covers my case. Number 2, my lords, the India Glycol judgment and other judgments which my lords have held, those are cases where people were trying to make their cases on merits of the case. I am not on merits at all. I am on the violations of the MSME Act. And I am trying to portray my case there, my lords. So my humble submission is basic structure 226, etc. will be attracted when statutory violations have taken place. If it was a case on in fact,
Problem is that you are yourself saying that you're not challenging it on merits, but only on statutory violations.
well, the merits grounds are also there. I'm saying for the statutory
merits which you raised was that that they were not registered as a micro MSME on the date of the agreement.
No.
To which there's a finding of fact concurrently that they were registered.
No, what has happened is those merits arguments are also there, but to distinguish my case from the previous judgments, that's why I'm trying to portray my cases there.
Goods sold, supplied, and delivered. You have not paid them.
No, my lords. That's not the case at all. My lords. The case, my statement of defense is not on record. My apologies on that. But what if the transaction is slightly different?
The balance of the principal amount of 24.82 lakhs was not paid.
My lords, I'm ready to deposit the principal amount. That's no difficulty at all. But the point is, my lords, my defense could not be brought on record because there's no procedure that has happened. There's no basic arbitration and conciliation norms that have been followed. In fact, my lords, there's one Delhi High Court judgment which says if it shocks the conscience of the judge, then the writ petition is maintainable, even against MSME matters.
In a petition under section 34, all these grounds, suppose in an arbitration, forget the MSME Act, arbitrator doesn't hear the defendant and passes an award. Is that not amenable to a 34 application?
I brought on, my lords, the mandatory provisions of Arbitration Act not followed, ground under 34, absolutely correct, my lords. But my lords, this is under the conciliation process of section 65 violations. So they may not be followed under the 34, my lords.
On conciliation.
And besides, my lord, one person hearing the matter, other person passing the award, who I don't even know.
But why did you not choose to challenge the award under section 34?
My lord,
all these grounds are available. That's your ground is a violation of public policy.
My lords, I'm only saying, my lords, that under the Jharkhand Urja matter, I'm squarely covered, my lords.
Thereafter, it becomes an executable decree, right?
My lords, may I say this, my lords?
For the writ is that you don't have to deposit.
My lords, may I say this, my lords? The Jharkhand Urja judgment which covers me is of 2021. My lord's judgment is of 2023.
Leave it open to you pursue your remedies under section 34.
I'm so grateful, my lords.
The petitioner had an efficacious remedy of challenging the award of the Facilitation Council under the MSME Act by taking recourse to the provisions of section 34(2) of the Arbitration and Conciliation Act 1996. This was the matter, the High Court was justified in declining to entertain the writ petition under Article 226 of the Constitution. Hence, we are of the considered view that the grievances which are sought to be raised in these proceedings can be addressed in a petition under Section 34, full stop. Any observations by the High Court on the merits in the impugned order shall not stand in the way of the petitioner taking recourse to the remedies to challenge the arbitral award.
I'll be hit by delay, my lords, because now
You can say you were bona fide pursuing your remedies before the High Court. What else can we say?
my lords,
We can't condone the delay, which is beyond now the 90 days.
my lords, that's there, my lords, but that will be rendered me, my lords. It's a good case on merits, my lords. My lords have seen what has happened in this case, my lords. In fact, my lords,
We have vested right in yours to their benefit. How can we obviate a limit set by Parliament?
my lords, I understand that, my
Then
lords.
really speaking, if it's barred by limitation, you should just dismiss it. Otherwise, your client will spend another round of.
No, my lords, but my lords give me liberty, my lords, may not fructify to my interest if the debt delay
That you've
aspect
done.
is not covered.
All right. But we'll not condone the delay here. You have to move.
My lords may only observe that I may permit it to raise these points. That will be, my lords.
At least you can always say that condone it, but we can't, because there's a maximum period which can be, which is condonable. We can't go beyond that, like the IBC, the Arbitration Act, etc. Condone the delay of 36 days in filing the SLP. There's no difficulty
No,
there. Then you can say I was pursuing my remedies bona fide before the Supreme Court.
I'm in my lord's hands, my lords.
You condone.
Item 11. I'm in.
Question sets aside, my lord, the well-reasoned decree and the judgment of the trial court. Para 15, my lord, it proceeds to record a wrong date contrary to what has been pleaded by the plaintiff himself. And then, my lord, says that we were at fault in not pinpointing it promptly. My lord, three things were missing from the impugned judgment. If your lordships may please see, my lord, page
You
1.
paid them 90% of the payment.
That's right.
Right?
Right.
So the dispute was only in regard to the balance 10%.
Lordship, please.
So the High Court says first, the very fact that you paid 90% shows that the work was being executed. Now, question is still, I mean, you may still have a point that, there were delays or deficiencies on the part of the respondent. Where did you raise the issue of delays or deficiencies?
No, my lord. We have said so in the written statement, coupled with the fact, my lord, there is a finding of fact that the work completed was only to the extent of 90%. And therefore, my lord, the learned trial court held this. My lord, please have a look at page 175.
So what evidence did you produce to establish that there were delays late?
Yes, yes. 30th of next year, P11, your lordships may see. Or my lord, lordships may please have an next year P12. Now, this letter, which we have pointed out, my lord, on 30th November 2012, the judgment in question says that you.
But tell us what is the evidence which you laid?
My lord, this was one of the letters, my lord, 30th November, and the rejection letters at document P11. Kindly just see, my lord, next year P11 from pages 102.
You had to prove your defense that there were delays and that there were delays or deficiencies by adducing the evidence of a person cognizant of the contract which was being performed, and then establish, by producing documentary material that, well, there was a shortage of work or there was measurement carried out which resulted in, a deficiency.
If I may say so with respect, my lord, next year P11 pages 102 to 115 were the rejection notes. Then, my lord, the chairman of the company appeared as DW1. And then, my lord, 30th November 2012 letter, which was within the warranty period, but not considered by the judgment in question, that has been set aside, my lord, on the premise that the work was completed in July 2011. But the plaintiff himself says that it was in 2012. Para 19, if I may just draw your lordship's kind attention, please have a look, my lord, at para 19, page 187. That is, my lord, the fundamental error, my lord, in the judgment. Besides the point, my lord, that para 19.
Ultimately, you are here under 136.
I know, my lord.
That's the problem.
My lord, only two respectful submissions. First and the foremost, my lord, the evidence, etc., my lord, even the bills which were presented. The learned trial court has held that these were not actually the bills which were submitted or ought to have been submitted. They have not been proved. Then, my lord, there is a heavy discrepancy on my pointing out the deficiencies, because the High Court says, my lord,
it's purely a matter of appreciation of evidence and not a case for. Thank you.
Right.
This has to be tagged. This has to be tagged. Ganpati deal.
This has to be done.
Benami.
But kindly see the tribunal's order for a minute. It's PDF.
You are appearing for?
Well, I'm on KV8. I don't know the
We've got other matters which are pending, so we'll.
Well, kindly see, because ultimately the tribunal, I had gone an appeal. The tribunal has decided this issue only on Ganpati Deelcom, not on merits. And with the liberty given that if review is allowed by the Supreme Court, please come back.
Therefore, we'll tag it,
The
we'll tag it.
request is because ultimately even my lords tag
We've
it.
got other matters pending. We'll tag it.
I'm not saying no, it's not that they are remediless. Tribunal says if the review is allowed, please come back to us. That's liberty.
We'll keep it here.
On merits, ultimately.
We don't want to follow a different course of action because this will affect other matters which are pending. So we should notice and chat.
Have dismissed the numerous matters.
We'll keep it. We'll keep it here, yes.
Well, ultimately because my lord will be sending back to the tribunal.
All right.
Right.
My lord, I'm humbly praying for a Passover, my lord.
Tell us what the matter is about. You argue.
My lord, the learned Solicitor General is leading us, my lord.
So for us, you are the Solicitor General at this moment. Tell us what the matter is about.
My lord.
The matter is about.
Argue for 5 minutes, then we'll look into.
Mr. Solicitor, just one second. Let your junior argue the matter. Please sit by his side. Yes. Tell us what the matter is about.
My lord, the matter is about non-filing of affidavit of admission denial along with the written statement, my lord.
So the High Court has relied on the Delhi High Court rules,
my lord,
according to which the list of documents has to be filed at a much anterior stage. It says affidavit of without an affidavit of admission and denial, right? So the written statement, it says, will not be taken on the record without an affidavit of admission and denial.
My lord,
that's the Delhi High Court rule.
That's the Delhi High Court.
That's why you have been non-suited. Now, what is your answer to that?
My lord, CPC Order 11, Rule 4, my lords.
Yes.
It is very clear, my lords. The affidavit of admission denial has to be filed after interrogation and investigation of the documents have been done, my lords.
And what does the Commercial Courts Act say?
Commercial Court Act, my lords. This is the Order 11, Rule 4 as amended by the Commercial Court Act, my lords.
Right, but which is the provision of the Commercial Courts Act?
My lord, the Commercial Court Act amends CPC.
Which is the provision of the Commercial Courts Act which you are relying upon?
Page 15, my lords, of the impugned order.
Solicitor said 15, so you said 15. Hello, we issue notice. Oh, right. Issue notice. We have heard Mr. What's your name?
Avinash Agarwal.
We have heard Mr. Tushar Mehta and Solicitor General with Mr. Avinash Agarwal. Issue notice. Tenable on till so and so further proceedings. Should we stay the proceedings? Further proceedings in the
The real question would be the High Court says
the rules will prevail over the Act, over the CPC.
There are 22.
Returnable on so and so. Pending till the next date of listing, there shall be a stay of further proceedings in the suit. Don't you know? Yeah, what happened was that they didn't file. One 23 days will issue notice on bill.
Advocate underwent some ISIS.
Item 14.
But I beg to appear on behalf of the petitioner. My lord, firstly, my lord, Honorable High
issue
Court.
is as to whether after the appointment of the arbitrator by the Calcutta High Court,
yes,
the Tripura Commercial Court could have refused to refer the matter to arbitration. And I think the High Court is
my simple answer to this, my lord,
the High Court had appointed an arbitrator.
Without examining and considering the records that were lying before the arbitrator, which is completely a separate set of pleadings, my lord, before the arbitrator. My claim before the commercial court is completely independent of the dealership
All this
agreement.
can be argued before the arbitrator. Why should we entertain it at this
But
stage?
the Section 11 application on the basis of which the arbitrator has been appointed by the Calcutta High Court, my lord, is based on arbitration agreement.
The long and short of the story is that it can be sent to the arbitral tribunal. Why should we?
My lord, my set of pleadings in the commercial suit is completely independent of the dealership agreement. I am not at all governed by the dealership agreement. There is a basic misunderstanding on the part of the court, my lord. Secondly, my lord, without considering and examining the records lying before the arbitrator at Calcutta, my lord, the court could not have at paragraph 18, my lord. If your lordship kindly turns to page 15, paragraph 16.
Ultimately, what has the High Court done? The High Court has said that let the commercial remand order and saying that the commercial court should consider this.
Yes. Man, there could be parallel proceedings, man, without looking into what was there before the arbitrator. The set of claims that were completely different, and my claim before the is a money suit, my lord. It's a simple money suit. It's a commercial claim. It is not a case of claim and a counterclaim. My set of facts are completely independent of the dealership agreement. Paragraph 10 of the plaint, my lord, that is a different set of facts. Secondly, my lord, the High Court had interfered with order.
Who are you actually? Who are you in the sense? Who is your client?
My client is the instant petitioner, my lord, who has filed the commercial court in the Tripura High Court, in the commercial division court in Tripura.
You are the dealer.
Yes.
You are the dealer.
No. Yes, I am a dealer. I am a dealer, but not eminently from.
Maybe you are saying that your claim is independent of the dealership agreement.
Yes.
Your status arises as a dealer under the dealership agreement.
No, that
So the High
dealership
Court says, please consider our order. It directs the commercial court to consider their order, appointing an arbitrator.
Yes. My lord, the arbitration agreement, which is between me and the dealer, maybe, my lord, it's an alleged document, is not at all a document which is with my custody. I have specifically stated in my plaint that I have never seen, this document has never seen the light of the day. In that event of the matter,